is Jordan Walker. I'm with the law firm of Seaver Walker Paget. Thank you for joining me this afternoon, this evening, to talk about eminent domain, to talk about this project that is potentially affecting your property. And with that being said, we are going to go ahead and get started. Probably going to be here for about 30 minutes. If you have questions, feel free to answer or ask them as we move along. I can answer them at the end if I haven't already answered them through my presentation. Again, my name is Jordan Walker. I'm with Seaver Walker Paget. Seaver Walker Paget is a eminent domain only, landowner only law firm. So we only practice one area of law at Seaver Walker Paget, and that is eminent domain. Beyond that, we only help out landowners that are faced with eminent domain. We do not represent utilities. We've never represented a utility or somebody who can take land, government or whatnot. We are landowner only, eminent domain only. And because this is the only area of law that we practice, and not only that, we've done quite a bit of utility work, quite a bit of power line work, quite a bit of utility work in general. We have learned quite a bit about how these negotiations move, how this process takes place, what to expect when a company like TVA needs your land for a power line project. So because we've learned so much, we've accrued quite a bit of knowledge, and today I am going to relay that experience to you, provide you with some advice moving forward on how to approach this acquisition on your property, and what to expect. So real quick, I do want to note why. One question we get a lot is why, the landowner asks, why did I receive a letter from you, our firm? And that's fairly common. The reason why you received a letter from our firm, again, we don't work for TVA. We only represent landowners. So we monitor projects across the country. This is a project that we have found. It's relatively timely, as our research indicates, which means that we expect acquisition to start here this year. And so we utilize that information, contacted our mapper, and used publicly available information, property tax records, things like that, to send you a letter based on our research. So, based on our best estimation, your property is one of the properties that is affected by this project, and that's why you got our letter. If you haven't heard from TVA, that's fine. If your property is needed, you will hear from them, and we'll get into that here in a little bit, what to expect. But I didn't want to stress kind of who we are, why you got our letter, and what we're doing. So the project, which is the Middle Tennessee Generation and Transmission Capacity Expansion Project, a lot of words. We're just going to call it the project. It is an upgrade of transmission line infrastructure in central Tennessee, Middle Tennessee. This is happening not only in Tennessee, but in other states as well, around the Midwest, where infrastructure is being upgraded. Transmission lines are being upgraded. This is one of several grid projects that we are monitoring across the Midwest into the South. And so essentially what's happening is a lot of utility companies in the area, in the region, are upgrading their existing infrastructure. It has been upgraded in a while. And this is one of those projects. TVA it's actually two different phases of one project, a 3-mile transmission line beginning at the 161 kV line near Sweet Thorn Road. And it would end at the Cheatham County substation, which is located on Lockardsville Road. So that's the first phase. It's a 3-mile line. The second second phase involves upgrading a transmission line near TVA's existing Davidson West Nashville transmission line near Apache Trail in Cheatham. Though that line will be using double pole H-frame steel structures on existing and new right-of-way, no less than 100 feet wide easement. And then the second line on the second phase is a 14 to 15 mile line near Mount Zion Road and ending again at the Cheatham County substation. Again, that's double pole structures on new 100-foot right-of-way. and then some additional right of way that might be a little bit wider. So this is the project effectively divided into two phases, three total lines. This is what they would like to build. And if you are interested in learning more about this project, I will say that you can go to TVA's website and you can Google the name of the project, the Middle Tennessee uh, Generation and Transmission Capacity Expansion Project, and you'll find all you need to know about the project. So let's talk about eminent domain because eminent domain comes part and parcel with these acquisitions. TVA, as a utility company, has eminent domain authority. Uh, utility companies largely either are delegated eminent domain authority or they have it inherently, depending on the state. In Tennessee, TVA has this ability, this eminent domain authority. What is eminent domain? Eminent domain is the power of entities to acquire private land and put it to public use. The most common exercise of eminent domain, the most thought of, is usually for road projects. But the more common exercise of eminent domain is really for utility projects, transmission lines, power lines, pipelines, distribution, sewage easements, anything, natural gas transmission line, ammonia pipelines, oil pipelines, all of these things. They all generally come with eminent domain, meaning the energy company, even though they're not a governmental entity, like the Tennessee Department of Transportation, they do still have this ability to utilize eminent domain. And ultimately, what that means is that with eminent domain, if you can't reach a deal with TVA, it means that they can ultimately sue you in the county where your property is located and get your land that way. Effectively, they use eminent domain as utilizing the court system to get title to private land to then put it to a public use. In this instance, it would be a transmission line. At eminent domain, and we'll get into a little bit more, basically eminent domain, it's generally all about money. That being getting just compensation for your land. You are entitled to just compensation. You're entitled to a jury trial. And that is usually what the eminent domain litigation is over. Now, I'll say that at eminent domain, you do have the option to file your objections to the acquisition and basically say that you don't want it to be built. You don't want them to take your land. And you can argue, you can make arguments if you like that they shouldn't be able to take your land. I will say that those arguments are usually very difficult to make. They're fact specific, fact intensive. You need to have a pretty darn good argument, and you not wanting it on your land is not a winning argument. We have definitely got involved with landowners in fighting or stopping these acquisitions. But again, they are very fact specific. They're not common. I'll say that stopping acquisitions is much more difficult than, for example, getting fair and just compensation for your land. You have a much better chance of doing the latter than you do the former. So something to keep in mind, but this is kind of a 10,000-foot view of what eminent domain is and why it's relevant to this project. So the eminent domain process, this is the procedure from beginning to end for an eminent domain acquisition. So in your situation, at some point I would expect this year, but again, I don't work for TVA. That's just based on my guessing, my educated guessing. I would expect that you're approached this year, maybe next year by TVA to seek to acquire an easement on your property. This is the pre-condemnation offer. So they will issue you an offer for your property. And for those of you that have not received an offer and not heard anything from TVA at all, not uncommon, nothing to be worried about. In these situations, they will certainly let their presence be felt. Utility companies do not exercise a light touch when it comes to negotiating with landowners. So that pre-condemnation offer, you will know about it. It's not, even if you're not home, they have a knack for getting in touch with landowners and getting the offer to them. Beyond that, they need to issue this offer as a matter of pre-condemnation requirements. In order to even file an eminent domain lawsuit, they have to issue you an offer and attempt to negotiate with you before the lawsuit. So they've issued you an offer, and that is when our firm gets involved. I tell folks, as soon as you get an offer, that's the time to hire an attorney. That's generally when folks hire us to help them out with this. They will issue the offer. There is going to be some level of negotiation. I wouldn't expect a lot. And then if a deal cannot be reached between the parties, eventually TVA will need to move forward with the property, and they'll need to get it, and they will file a condemnation lawsuit. Condemnation is just another word for eminent domain. It's the procedure through which the power of eminent domain is exercised. So they will file the lawsuit in the county where the property is located. And again, you do have a right to a jury trial over compensation. Uh, and ultimately, as I discussed on the previous slide, the matter becomes once it reaches litigation, it is, unless you're attempting to stop the acquisition, it usually is almost entirely about money and compensation, what you're entitled to. So that is kind of the beginning to end. I do want to stress that this is not how every case goes. I'm not telling you right now that your case is going to be in trial or you're going to be in eminent domain. That's going to depend on your case. It's going to depend on TVA. How willing are they to work with you? How willing are they to negotiate with you to get you what you want? Sometimes cases require trial. Sometimes cases require litigation. And then sometimes the cases that require litigation require trial. Not everyone will require that. It'll really just depend on your case. I would say a good majority of our cases, utility cases specifically, don't reach eminent domain. A good majority of them settle without requiring eminent domain, or a large majority of them settle at litigation without necessitating a trial. But we have had eminent domain trials. They are not very common, but we do them, and we are prepared to handle yours, of course, as well. So I want to talk about, now we've talked about eminent domain, let's talk about what they are going to want from you. What does TVA want from you? And I like to break it down to fundamentals. TVA is going to want an easement from you. And an easement is effectively a deed, but instead of deeding your property to, if you're selling your home, you deed the property to the buyer, the entirety of the property. They take it and you don't own it anymore. With an easement, it's like a deed, but you're only selling the right for the buyer to do certain activities in a certain location on your property. Effectively, you're deeding them the right to do what the easement permits them the right to do, which means that the number one question I get from landowners is, with these acquisitions, is TVA allowed to do this? Am I allowed to do that? Can I farm? Can they build fencing? Can I build fencing? What about livestock? What about timber? Can I hunt? All of these things. What are they allowed to do? What am I allowed to do? It all depends on what the easement says. The easement is going to be the most important document you sign. It will convey the land, and that easement will have all of the requirements of the easement, all of the conditions, all of the responsibilities, duties that you impose on them, duties that they impose on you. Ultimately, the easement is the most important document. You need to ensure that that document is well crafted and documented fairly. The reason why is a lot of times on these acquisitions, unfortunately fairly common, the easements that utilities like TVA propose to landowners are not fair. They ask for way more than what is necessary. They are incredibly broad. They ask for broad access rights. They eliminate liability in the future. They don't hold the landowner harmless for acts of their negligence. They include the right to sell their rights, including the right to build pipelines, build another power line, build as many power lines as they like. No clauses that require proper ground restoration. These are all clauses that you need to make sure are in your easement. It is incumbent on you, the landowner, to make sure that the document they are saying, what they're telling you, is actually reflected in the document. Often, what is told to landowners about the easement they're signing doesn't necessarily reflect what the easement actually says. And that's important because, to my final point, easements are forever. It doesn't matter if you sell your property. It doesn't matter if your kids inherit it. It doesn't matter if your grandkids inherit it. They will take the property subject to this easement. It will be there forever, which means even if you don't care about it for your sake, the easement language, you should care about it for maybe your kids or grandkids' sake, because they're going to be having to deal with the easement language that you signed. Ultimately, again, there's nothing that they're not gonna be allowed to go to TVA and say, hey, this isn't fair. Can we change it? TVA is gonna say, no, these are our rights. So, because they're forever, because they will be the burden of whoever takes over your property, it is incredibly important to make sure that whatever you're signing is has been reviewed by a lawyer, and it actually says what they're saying it says, and not what they would like what you'd like it to say. Uh, so that's the big key. That's the first big key for your eminent domain case is the language of the easement. The second big key to your case is going to be money. Um, so if the easement needs to be drafted correctly and you need to be compensated correctly. A complete compensation package should include all of these things. They should include a proper price per acre for your land. It should include proper payment for crop and timber damages. It should payment for anticipated soil and ground damages, or a clause requiring stringent remediation standards. It needs to have proper consideration of all damages, field tile, irrigation, all compaction, flooding. All of these things need to be considered, and they need to be encapsulated in the agreement that you are signing. And this is, of course, in addition to bonus payments, anything offered by utility, because generally these are not offered by the utility, and they are items that you're going to have to negotiate into the agreement. So we talked about what's good, what a good result would be, and a good compensation and a good easement. Let's talk about what you're going to face in trying to get these accomplished, and that is right-of-way agents. Right-of-way agents are agents that work for the TVA. They're third-party contractors. Well, I should say they work for a company who they themselves was hired by TVA. Right-of-way agents are, their job, their duty is to acquire your land, and they exercise a number of strategies to try to do that. And we've seen a lot of them. I've talked to my fair share of right-of-way agents. They try them on me, and it doesn't really go far. But these are just really kind of sales tactics, almost as a way to put it, because they're selling the landowner on the idea of the landowner selling their land to them or TVA. So they like to be your best friend or your worst enemy. They deploy whatever they feel is necessary in the moment. Again, ultimately, something we see is right-of-way agents try to make it seem like they're on your side, and they usually like to tell landowners that we want to this power line is going to be here forever. Let's start the relationship out on the right foot. Yada yada yada. Here's the easement. We feel this is fair, so on and so forth. So it's important to remember that they are where they're coming from and who's getting paid and who's incentivized to do what. The right-of-way agent is incentivized to acquire your land. They are not incentivized to give you more money, to help you out on the easement, to do anything else. Their job, and they are paid to do so, is to get your land for as cheap as possible. So just remember that when you're dealing with these folks, remember, who is paying their paycheck, and you can, follow the money, so to speak, and you can usually determine how credible what is being told to you is. These are some strategies we've seen, some things to look for. Understand that they love to do things verbally. We have a slide here in a bit. They love to make it seem like, again, like they're doing favors to the landowner. They're offering more than fair market value. They'll offer bonus payments to incentivize a quick decision, because quick decisions are usually not good decisions. They'll scare folks and say our number is gonna go down. It's gonna go up if you take it now, or you'll lose it. These are all tactics that they exercise to get landowners to make quick, rash decisions for low money. And it's up to you to exercise your right to say no. And you do have the right to say no. You can absolutely say no. You don't have to accept their offer. You have no requirement to. What I tell people is that if you aren't sure if it's a good deal, or you want to find out, you can just ask me. If you have an offer and you send it to me, I will look at it for free, and I will give you my thoughts. One thing that they like to do is they love to talk about, they love to talk about, or engage in this little shell game is what I call it, where they love to talk about low dollar things with landowners. and that is uh, topics of conversation where they are not talking about significant money. For example, if you have a 3 acre acquisition, easement acquisition, and they're offering you $5,000 or $6,000 an acre, and you think it's worth 7 or 8, and you start negotiating over $7,000 or $8,000 over a 3 acre easement, you're already playing into the right-of-way agent's hands because they love to have a conversation over $5,000, $6,000. What they don't want to have a conversation is how does this power line affect the rest of the property? How does this power line affect the ground itself? Uh, any impact that the power line has to items, anything, the land itself outside of the easement is called residual damage. And you are entitled to that. It is rarely offered by transmission lines. Uh, Property damage on top of that. This is going to be significant construction. It's going to mess up the ground. You need to make sure that you get paid for it, or there's language in there. So just things to consider. Ultimately, if you're not sure, just shoot me an email, give me a call. I'm happy to look at your offer. So I'm almost the end of my presentation, and then we'll open it up for questions. I see there's already one, and we'll get to that at the end. So this is what you should do when you receive an offer, or when you're about to receive an offer. First, insist that the right-of-way agent communicate via email only. I do this because verbal promises mean nothing in negotiations, especially when it comes to transferring property. All the nice things they tell you, your kitchen counter, your living room, don't mean anything if they aren't in the document. So when they make verbal offers, and they, they write an offer down on a piece of paper, take the paper with them. That's not how it works. I would insist that they communicate via email only, so you have a record of the things they're trying to promise you. If they're willing to promise it, they can put it in writing and they can send you an email. Otherwise, it doesn't mean anything. So I would insist that there is a record, insist that they communicate via email or text. Text is fine too, as long as there's a record of the communication. Once the offer is received from the right-of-way agent, I tell landowners, inform the right-of-way agent via email, thank you, I will review this and get back to you in a week. And in that week, you call me or you call an attorney or whoever, and you say, hey, take a look at this. What do you think? And then you get back in touch with them in a week. I will be able to look at your offer and review it within an hour, a couple hours at that. So, but just keep in mind, this gives you a week, gives you a buffer. You're not putting them off, so they're not going to rush to eminent domain. It makes you seem like you're taking it seriously, which is important. But also, it's giving you some time to get a plan together and respond appropriately. Again, avoid in-person discussions and negotiations with right-of-way agents. What not to do. Do not jump into negotiations. Do not enlist an appraiser. Do not meet in person with the right-of-way agent. Do not assume the utility has their interests at heart, and do not make a rush decision, but also don't ignore it altogether. I'll go through each one real quick. You can negotiate, of course, with the right-of-way agent, but before you do that, I would first contact somebody that knows what they're talking about, because you might start negotiating from a position that you don't want to. They come to you and offer you $10,000, you might think, oh, well, I'll ask for 20. That's a good deal. It must be, because they're offering 10 and 20 is twice of that. And what happens if you come to me and you say, well, what do you think about this? And I say, well, actually, you should be getting 80 or 90. The problem is, in that scenario, if you already went to the right-of-way agent and said you take 20, they're going to write that down. They're going to keep that with their file, and they're going to know you would have taken 20, and it's going to be very difficult to get them to not to back off of 20, because they knew you'd take it. You revealed your hand before you even knew what you had. So that's why we recommend not jumping into those discussions without first talking to somebody. Do not enlist an appraiser. They are not necessary, and they're very expensive. They are, in our view, appraisals are only necessary at litigation. Until that point, you might be just wasting your money on something you might not need. Okay, and this is my final slide, and then I'm going to open it up for second to final slide. This is how our firm operates, just a brief example if you were interested in hiring our services. We work largely on a contingency fee basis, meaning we only get paid if we get you more than what is offered. In this example, if you were offered $10,000 and you hired us, and we got you $50,000, we added $40,000 to the case, we get 1/3 of the 40. you end up in this scenario with about $37,000, almost 4 times the original offer. What happens if you hire us and we don't get you more than what is offered? We don't get you another dime. We do not collect a fee. We only collect a fee if we get you more than what is offered. The reason why we do our agreements like this is because it allows landowners to hire us without coming out of pocket, and it allows some level of trust to the landowner because we're all incentivized, we're all in the same boat together. We're invested in the case. We're a partner at this point in your case, and we would like to get a good recovery for you, just like we'd like to get a good recovery for us. So that's why we do it that way. If you're interested in a billing or a more traditional retainer agreement, we can absolutely talk about that on a one-on-one basis. So this is the last slide, and I'll let you guys ask some questions now. If you do have any, go ahead and put them in the chat or put them in the Q&A, either one, and I'll get to them. But do it now so we can address it here once we're done. As soon as you receive an offer, you should hire an attorney. Until that point, I would say continue vet your attorney options, consider a strategy attack. How are you going to approach this? Try to learn about the project, see if you can figure out from TVA's website, more about the project. Uh, Identify priorities, issues you have, goals that you want to accomplish, things you're worried about in your property, specific property issues. You've got a pond, if you're worried about erosion, is there a road they're going to cross? Every property has unique characteristics and requirements. So that's start getting in touch with, start preparing yourself for this acquisition. Get your ducks in a row, so to speak. If you have a group of landowners that can provide a lot of leverage to a landowner. It's not required, but it is. We represent groups a lot. When I say represent groups, we represent a lot of individuals that make up a larger group. We still represent every individual with their own issues. But if you have a group of folks, that can be very helpful for the landowners within that group. It can increase your leverage quite a bit. Okay. With that being said, I do see some questions. I will get to those. If you have offers, feel free to send them to my email address right there. You can also text it to my cell phone right there. You can fax it there as well. Again, I do not charge for offer reviews. These are completely free, and I'm happy to do them as part of our job. Okay. Mark had a question. Shouldn't just compensation include the loss of value to the rest of your land in addition to the fair market value of the land they purchased? Yes, absolutely. That is residual damage. And we touched on that a little bit, but again, I'll just repeat. Residual damage is the impact on your property's value outside of the easement that they want. Generally, it's revealed through stigma associated with having power lines on your property. If you have a 10-acre lot that doesn't have a power line and you have another 10-acre lot, they're identical, they're right next to each other, but it does. The residual damage is the difference in value between those two plots of land. And you are entitled to that residual damage, that impact on the remainder, the land outside of the acquisition. So to answer your question, yes, that is part of just compensation. It's an item that we argue quite a bit. Alan had a question. Will I still be able to use the land under the power lines, or does the easement completely result in a loss of the usage of the land? I will say that it's important for you to ensure that your rights are protected in the easement. I will say that generally speaking, without having seen the easement presented by TVA, generally speaking, power line easements like this permit the landowner to continue to use the property. But ultimately, all that matters is what that easement says. Without seeing the easement in front of me, I can't tell you if it allows you to do that or not. I can just speak generally. I can also say that if it doesn't, then you definitely need to hire somebody to make sure that it allows you to use the land. Because if you can't use the land within the easement, then that easement became a lot more valuable. It effectively bisects the property, or if it goes through the middle of it, if it goes along the property line, it would have a pretty significant impact. So either our motto generally in these scenarios is they can fix it or they can pay for it. So either they can allow you use of the land under the property, or they can pay for what that means, and it's usually pretty significant. So it's either fix or pay for it. That's kind of our motto. Okay. Are there any other questions? Okay, I am not seeing any other questions, which is fine, not a problem. This will be recorded if you'd like to watch it another time. If somebody else if you know somebody that wasn't able to see it, they can still register and view the recording of this. Other than that, if you have questions, please don't hesitate to contact me. If you have an offer, please go ahead and send it. I'd love to look at it. Other than that, oh, there's one more question, and then I'll let everyone go. Is it unreasonable to ask to have tower position in certain areas, such as in a fence row or edge of field? No, it's not unreasonable. Pole locations are fairly common. Asking for pole locations in specific places, not unreasonable. They're ultimately you're going to be at the whim of TVA and what they can and can't do. You know, deviations. One small deviation can have a huge impact. We don't know that. We can't know that. We don't work for them. We don't have their schema or their schematic. So no, I don't think it's unreasonable to ask for that. That's something that's part of our negotiations. Generally, is negotiating pole location to limit the impact. So not unreasonable. The question is whether or not you can actually get them to do what you want. Okay, you're very welcome. Okay. Well, with that being said, thank you again for stopping by. If you have questions, let me know. Otherwise, again, thank you. Good luck and stay in touch.